Good morning and good evening to everyone. My name is Jenny Ramesh, and I'm the co-founder and creative head at CareSpaces. On behalf of CareSpaces and SNS Arts Development Consultancy, I would like to welcome every member of our diverse Indian arts community to the second session of our 5-part series, I'm a Professional Too. When we all say or hear the words, I'm a professional too, we are committing to providing respect to one another. In our first session, we discussed facets of ethical professional conduct in the context of workspaces. These aspects also apply to the nature of our work, which is most often creative and original. This creativity is the common thread that holds our global Indian arts community together. The pillars of ethical professional conduct begin with the work that we do and share with our community. With SNS, we share the common goal of bringing more accountability and ethical professional practices to our Indian arts spaces through this series. The second session specifically articulates what this respect looks like in terms of accountability and ethical professional conduct in the realm of creative IP, how we can protect our own and respect the IP of others in this space. So here is Protect Your Creative IP, the second session of our series. I would first like to introduce our moderators for this session. Kritika Rajkumar. Kritika Rajkumar is an attorney practicing complex commercial litigation at Nixon Peabody LLP, a top 100 global law firm, and is the head of legal and compliance at CareSpaces. Combining her passions as a trial attorney and Bharatanatyam dancer, Kritika believes that the formalization and promotion of ethical conduct in the Indian art space can result in a safe environment where creativity can thrive. She regularly strives to create and share her art on public domains in an ethical way and is passionate about ensuring other artists are also equipped with the tools to do the same. Here is Kritika Rajkumar. Our next moderator is Ratipriya Suresh. Ratipriya Suresh is lead UX UI designer for a product and technology team at Alexander Mann Solutions, an award-winning UK-based talent acquisition firm. As a UX designer and Bharatanatyam dancer from the art space who has often managed high security compliance and many NDAs with Apple, Comcast, Verizon, and more, Ratipriya values phonetical attention to detail when it comes to creative IP accreditation. As head of design and lead UX UI designer at CareSpaces, Ratipriya will help you find your voice in the space and rekindle the love of pursuing the arts in their purity. Here is Ratipriya Suresh. Once again, I'm Janani, co-founder and creative head of CareSpaces. I, along with Aishwarya, illustrator and interactive designer at CareSpaces, will be managing all tech for today's live broadcast. Now I will hand it over to our moderators to get the session started. Thank you.
Thanks so much, Janani, for the introduction. We also want to recognize our CareSpaces core team members who are working behind the scenes to make sure the session runs smoothly. I'll hand it over to our first team member, Priyanka.
Hi, I'm Priyanka, co-head of resources and research at CareSpaces.
Hi, I'm Sachin, education and peer support lead at CareSpaces.
Hello, I'm Sutikshna, education and peer support leader at CareSpaces, and the three of us will be handling Q&A on our live YouTube broadcast and in Zoom. I'll now hand it over to Guhan from our CareSpaces team.
Hi, I'm Guhan, co-head of resources and research at CareSpaces. I'll be doing the wrap-up at the end of today's session, and I'll hand it over to Neha from our team.
Hi, everyone. My name is Neha. I'm co-founder and head of finance at CareSpaces. Today, I'll be helping with session summaries at the end of our session. I'm going to hand it back to Ratipriya and Kritika to start our session.
Thank you to everyone who is joining us today, and thank you to all of our team members for the back-end help. We acknowledge the hereditary artists throughout India and recognize the importance of their contributions to the art forms represented on this panel today. We pay our respects to their community, past, present, and emerging.
This discussion features voices from the creative Indian performing arts, and we understand the privilege that comes with access and proximity to these art forms. Although we may come from different ecosystems, this is a safe space. So we are all approaching this conversation with mutual respect, empathy, and active listening, and believe anyone and everyone is equal, regardless of age, gender, or experience. We request both our speakers and listeners to do the same.
The information discussed today is for informational purposes only and should not be construed as legal advice. Additionally, any information presented by CareSpaces or the panelists through PowerPoints or handouts are for informational purposes only and should not be relied upon as legal advice. Please be advised that while our panelists are experts in their respective fields, they will not be able to answer any questions pertaining to specific scenarios or give legal opinions or advice around your specific situation. So please refrain from using actual names of people, organizations, or other entities. With that, I would like to get started by introducing our first panelist, MS Bharat. Bharat, the founder of Kriya Law, currently serves as APAA International Council member, president of IPASI, and immediate past co-chair of INTA India Global Advisory Council, and immediate past vice president of APAA India Group. His practice includes intellectual property litigation before Indian high courts, opposition, cancellation, and other related proceedings before the Trademark Office, Intellectual Property Appellate Board, Copyright Board, and Geographical Indications Office. He has been the lead counsel in numerous proceedings with several reported decisions to his credentials. He represents a wide range of clients, including multinationals, artists, a band, and a leading actor who took his name on screen to play the role of a lawyer. Everyone, please help me welcome MS Bharat to our panel.
Good morning and good evening, everyone. It's a pleasure to be here. And for the next couple of hours, we'll be having a wonderful session interactively. And I look forward to it very soon.
Thank you. Welcome, Bharat. Next, I'd like to introduce Leah Pardey. Leah Pardey is a trademark attorney at the United States Patent and Trademark Office. She is a graduate of the American University of Washington College of Law in Washington, D.C. During her third year of law school, she worked as a student attorney in the Intellectual Property Law Clinic, representing clients with their copyright and trademark matters. Specifically, Leah's clients included documentary filmmakers and fashion designers. Leah's current work at the United States Patent and Trademark Office focuses on trademark examination and registration. Everyone, please help me welcome panelist Leah Pardey. Once again, welcome to our workshop participants. Go ahead and turn your videos on based on your comfort level for us to interact together for today's conversation. In today's workshop, we will accomplish the following objectives in 3 parts. In part 1, our lawyers will walk you through the law to provide you some context. In part 2, we will apply the law to real-life case studies. And part 3, we will give you some practical takeaways for questions you may have about protecting your IP. Those of you participating in Zoom can follow along in the worksheet we provided, currently being pasted in your Zoom chat, and take notes at your leisure. Those of you watching live on YouTube, welcome. You can utilize the PDF we've linked for you in the YouTube description box. This worksheet is meant to be a guide reference for you throughout today's workshop.
During today's session, if you're a participant on Zoom, please ask your questions in the chat. Colin from SNS Arts Development Consultancy will be compiling your questions to address at the end of our session. Thanks so much, Colin, for helping us with that. Please stay muted until our CareSpaces Tech Coordinator unmutes you during part 2 of our session with the case studies. Use the raise hand feature located at the bottom right of your Zoom window to ask a question during part 2 of the session. For those of you watching via YouTube, please type in your questions in the chat and we're going to address those questions at the end as well. All right, so let's begin. I want to start by asking Bharat and Leah, and we can start with Bharat, maybe can start off. What exactly is intellectual property?
Thanks, Kritika. Intellectual property is like any other property. An individual or a corporation or an entity has many types of properties, right? So it can, the traditional way we used to have goods, we used to have factories, we used to have real estate, land, building, and over a period of time, the last 150 years or so, they also realized that any property created by the intellect, by the creativity or the invention or a brand which is intangible, is what intellectual property is. And there are about 7 or 8 different buckets. depending on the nature of the asset. There are brands, which we call it as trademarks. There is looks and shape of the product, which we call it as designs. There is the creative world, which is the widest of them all, which we are talking about today, which is literary work, artistic work. It can be cinematographic work, drama, sculpture, dance, software, database. I mean, that's the widest of them all. And then there is integrated circuits, and then many, many more. But as of today, if you want to know what is intellectual property, it's an intangible property. You can't touch them, you can't feel them, but it's all around us. Each of us have our own intellectual properties, and there is no person in the world who doesn't own intellectual property. So we will come to that eventually. But as a bird's eye view, all of us have intellectual property, and every product has an intellectual property.
Leah, is there anything that you want to add from your experiences on what you believe intellectual property is?
I think everything was covered except that it is, just to reiterate what he said, is just creations of the mind and the intellect. And it's about creative works and it's about inventions.
Awesome. So the next thing I want to talk about is we have a lot of registrations for today's session from all over the world. There are people from Europe, from Canada, various parts of the United States, and also India. So, Bharat, why don't we start off with you? Can you talk a little bit about the importance of understanding intellectual property laws on a global scale? And I am asking this because Indian arts has sort of expanded across the world. It's no longer just practiced in one country or one space as it used to, hundreds and hundreds of years ago. So if you could speak to sort of the global significance of these laws and why it's important for stakeholders in our space to understand these laws on a global scale.
Well, it's not just in the recent past, but intellectual property, unlike physical property, is capable of going beyond boundaries. Of course, the boundaries are also notional. There is no physical boundary in a real world, but beyond nations, and especially in the recent 20-year history, when digital revolution came up, the way we consume products, the way we consume music, the way we consume art has taken a completely giant leap. But the laws have not been amended because they've been very, very broad enough to cover a lot of these cross-border geographical protection. There have been very slight, insignificant amendments, but we will come to that later. But if you look at trademarks, which is brands, which you look at patents, which is for inventions, which you look at designs, which is for the look and shape of the product, they are country specific, which means when you take a registration, it is registered for that particular geographical territory. But something unique, which is about copyright, which is very heartening for all of us in the creative world, is that most of the countries, I'm told about 179 countries till date, have signed up a convention called the Berne Convention, which was signed originally by 6 countries in the year 1886, whereby if you were to make a creative work in any one of those 179 countries, it will be protected in the remaining 178 countries without it being registered specifically. So the minute you get bored today of the lecture we are giving you or this discussion, and someone is making a caricature of the 4 or 5 of us, that person immediately becomes the copyright owner. And if they take a screenshot of it or take a photograph of it and upload it on the internet anywhere, instantly they are protected. That work is protected in all the 179 countries, except a few countries like the US, where if you want to take an action against a copier, the local laws compels you to seek a registration. So I think Leah would be more apt in talking about the compulsion for having a registration in the US to take an action. But in India, I can say You don't need a registration. All you need to prove is that you are the owner. So the registration to that extent helps you easily prove that you are the owner, but it's not a compulsory.
Yeah, thank you so much. That's a perfect segue to our next segment because we're going to break down some of these areas of law, copyright, patents, trademarks, and Leah's going to sort of walk us through some baseline definitions on the US side. And then I'm going to ask Bharat at the end of each of those sections to sort of talk about comparisons on the India side. And I think it's so important for all of us to know this, as you mentioned, because there are exceptions to these general rules. And especially in the US, that so many stakeholders in the Indian arts come and perform in the US. So I think it's so important for us to understand this. So Leah, with that, I hope you have access to your slides. And at this time, you can sort of walk us through first copyright and then trademarks and then patents. And at the end of each section, I'll sort of interrupt you a little bit to just have Bharat sort of put in his little words of wisdom on the Indian law. So take it away.
Yes, thank you so much. Good morning and good evening to everyone. First, I'd like to go over copyright law. And that's one form of intellectual property, and it protects tangible works of art, literary works, dramatic works, musical works, etc. And for a work to be copyrightable, it needs to be two things. It needs to be original and it needs to be tangible. And that second factor, the tangibility of the work, is very important because ideas itself are not protected under copyright law. So if, for example, if I was a writer and I have a unique original story in my head, I would have no copyright to that story until it is put down and written down on pen to paper. And once I write that story down, a copyright will automatically affix to that work. However, in the US, you must register your copyright in order to enforce it. And enforcing it means you could stop other people from using your copyrighted work.
Thank you so much, Leah. So, Bharat, on that side, I know you talked a little bit about it in terms of the fact that India doesn't require registration, but are there any other similarities or differences on the Indian side? And are there any trends emerging now that are sort of going towards the side of requiring registration, or are courts sort of recognizing registration as being more important?
Interestingly, 3 days back, the Bombay High Court categorically confirmed that registration is not mandatory. But what happens is if I own a house and if I were to shoo away persons who are trespassing, and if I were to go to the authority or the court, I need to prove that I'm owner of the house. So imagine the copyright you have is a fenced land or a physical property and you want to shoo away trespassers. How do you prove that you are the owner? You need to have some circumstantial evidence to show that you created it or you acquired it. The easier way is to prove by way of a certificate, which is the registration certificate. Though it is not mandatory, for ease of proving that you are the owner, registration is advisable and comes at a very, very cheap and very, very fast mechanism. It takes about a couple of months to get registration, unless it's for a logo, which takes much more time. But generally, for a dramatic work or an artistic work or a literary work, it comes in a couple of months and a few thousands only.
Great. Thank you so much for that. So let's move on now to our next segment, which specifically talks about fair use. I know, Leah, this is something that you wanted to talk about because it's an exception to copyright. So how does this whole concept of fair use fit in?
So if you register your copyright in the US, you would have to register it with the United States Copyright Office. And this helps you protect your copyrighted work and it refrains others from using your copyrighted work. If another person was to use your copyrighted work, they would have committed copyright infringement. And copyright infringement is the unlawful use of a copyrighted work. Fair use is actually an exception or a defense to copyright infringement. So fair use recognizes that some uses of another person's copyrighted work can be regarded as fair. And usually someone will use the work, another person's copyrighted work, for criticism, commentary, teaching, and news reporting. So for example, if I was making a documentary film about United States history. And I used a 10-second clip from a news report, and I put that in my documentary film. That could be regarded as fair use of that little clip because I'm using it in my documentary film to comment on some type of aspect of that US history. So it's very useful and it's very common in these specific purposes.
Got it. And so if somebody wanted to show that their work was sort of fair use or that they're not infringing on someone's copyright, how would they go about doing that, at least under US law, if you could talk about that a little bit?
Sure. So copyright is, or fair use is really determined on a case-by-case basis. And one of the considerations when determining if something is fair use is how transformative was that new use. So if that work is being used in a different way from its original purpose, and that artist is putting in their own creativity into it and they're putting in their own artistic works, and that's changing it and transforming it in a way that it's taking it out of that original context or original purpose and then having its own meaning. So if I was an artist and I wanted to make a collage and I was taking little clippings from books and magazines, all different places, but I'm using those clips and I'm putting it into a collage. I'm adding my own creativity, putting my own message to it. And it's almost like unrecognizable from what it was if it was a clipping of a shoe and in a shoe ad. And once it's put into this collage and I've added my own meaning and all these other pictures with it, it's almost unrecognizable. So I have transformed it and I've put it in my own way. And that would be an exception to the fair use.
Got it. And so, but on the Indian side, is it similar to that? Are there any differences under Indian law? And is this concept of fair use relevant in India?
Absolutely, it's almost the same, except that they have kind of extended the recognition for literary works in a 2016 case, which was fought before the Delhi High Court, where the Delhi University students were taking photocopies of large books for their own use, for annual use. And then the publishers went after them, went after the photocopying companies, saying that it was not allowed. And whether it's right or wrong, the High Court has held, and that's become affirmative, that that's fair use. So fair use is almost the same across the world, but it's not something which is not included in fair use is inspirational. We will talk about it later.
Awesome. Let's segue now into trademark. And Leah, this is your area of expertise. So I'm excited to hear about this side from you. If you can talk a little bit about trademark and what it is and how you can protect your brand.
Yes, the trademark is another form of intellectual property, and it protects words, designs, or symbols that helps consumers identify a source of a product or service. So just like copyright law in the US, you must register your trademark in order to enforce your trademark rights against someone else.
Okay, so I know on the slide you have that you can protect a name, and there are a lot of Indian artists and Indian art, they tend to be solo artists. So can you also protect your name as a brand in and of itself? Are there any specifics to that?
Yes, your name is trademarkable unless it is just your last name. So if you're just trademarking your surname, that is generally not allowed. If you put in your initials or if you put in your first, middle, last name, then that would be trademarkable unless there is someone else with that specific name that is using it for the exact same way that you're using it.
Got it. And so, oh yeah, sorry about that. So
oh, no, go ahead.
On the Indian side, is it similar? I know there's no registration component, I'm assuming, for trademarks similarly, but are there any other similarities and differences with trademark under Indian law?
No, I mean, personal names are always registrable, especially when you have an established name in the industry in your relevant, field of work. As rightly said, by Leah, if you have just Sachin, you can't register the name. If you have just Tendulkar, you can't register the name. But if you have Sachin Tendulkar, probably it's a fuller brand which is registrable. So the refusal will be for either part, but the whole can be registered because that stands out quite easily. And there are more and more artists who come forward and start registering their brands because they are starting to commercialize it on non-linear products. I mean, crossover products, and that's how it's just not cassette sale anymore, right? It's all online. So to extend branding and footprints, they do register it for music-related accessories as well.
Totally. That makes a lot of sense. And so let's move on to our last area of defining, which is patent law. So if Leah, you could talk a little bit about what patents protect, why artists in our space might want to use patents as a means of protecting their IP, and then I'll have Bharrat chime in.
Sure. I was going to just mention the three things about trademark before I move on to patents, which is important about trademarks when you're thinking about your brand, is that making sure that your name is distinctive in the context of your goods and services that you're providing. For example, if I was selling shirts and my brand name was women's shirts, that would not be very distinctive. It would be actually descriptive of the goods that I am providing. So that would have a little trademark significance. Another thing to consider is whether anyone else is using the same name in something that is related to the goods and services that you are providing. And the third is that your brand is not misrepresenting the nature of the goods and services that you're providing. So if I have a name and it has the word organic in it, but my goods are not organic, that would misrepresent the nature of my goods, which is generally not allowed.
That makes a lot of sense. And something that actually popped into my head just now is, what if somebody has my name? Like, what if I want to register my name and somebody actually has the exact name already registered? Does that mean that I'm no longer allowed to register my name as an artist and I would have to change my name or go by another pseudonym or something like that?
So in trademark, it's usually the first person to file and register, they will have the rights over you. So what's really important is if you want something to be registered, you should file an application to register that mark right away so someone else doesn't come in. There is some things that you could do. You could ask for a coexisting agreement where the owner would actually contract with you and let you use that name. But that's just up to you and that other person.
That's really interesting. I did not know that. So thank you for that. All right, now if you both are ready, we can move on to patents. So what are patents? What do they protect? And why would an artist have any use for patent protection in this space?
Sure. A patent is another field of intellectual property that grants an inventor the right to exclude others from making or selling or using that invention for a certain period of time, which is generally about 20 years. And the difference between patents and trademarks and copyrights is patents have some certain type of functionality to them. There's some type of unique invention. So if, for example, if there is a certain type of wheel on, let's say, just say a luggage, and that has some unique function and some unique purpose, if someone would like to enforce that patent rights, they would register it with the United States Patent and Trademark Office. So it's all about here is all about the functionality and the specific purpose, which is different from copyright and trademarks. They don't really have a function to them.
Got it. And Bharrat, I know that you have some firsthand experience with patents because I believe you've worked with musicians who have tried to patent their musical instruments. So if you can speak a little bit to that and sort of talk on the Indian side, like what you've seen with artists in the space utilizing patents, that would be awesome.
Sure. I mean, it's not very common, but in the music world, unless you are a electronics engineer and have a very large set of mixer and those kind of electronic gigs, you may not know about patents. But before we get into the specifics of what possibly patents can apply for musicians, if you look at just one product, like this is a keyboard amplifier, and you can take the same product and see what different types of IP are residing in. So the brand might be Roland or Yamaha. The design is how differently shaped they are, how they are looking to the eye. And the patent is how it functions, as in the functionality or the utility part of it. So, and this is something which is sold online, which is on Saptaswara Musical, which is in Chennai, Malapo, and they have a online website. So they have some e-commerce and information technology related issues as well. So in just one web page, you've seen about 4 or 5 different IPs residing. So having said that, you also, I'm sorry, I just need the remote back. So having said that, it's not too complicated to understand how possibly patents can be applied to musical instruments. So as I already said, the brands can be Casio, the look, shape, and pattern would be a design, and the patent would be a novel and a non-obvious functional element. But to speak more about the art industry and the music industry, here is an example of a very, very accomplished multi-instrument player. So he was earlier, he still continues to work in Philips and GE, one of the 2 companies, but he is also an accomplished artist, and he came out with this new invention of a completely new looking or new product, which is called a continuous pitch wind musical instrument. And if one were to look at the technical side of it, this is how they would explain this. We will share the slides later for us to read through it all through. I can possibly read the first few lines for you to understand. A musical instrument includes a resonating pipe having a first slot defined along a length of longitudinal axis. I'm stopping there because it's too technical. It's written by a patent lawyer for a patent grant. We don't need to sweat through that because that's something which your patent lawyer might do. But if you look at it, it's got a slider and the person is blowing through a slide, and this is the inventor, and he is playing. The instrument is called Chitra Venu, and this is how the new invented product looks like in this place. So as you see, it's got a slider, and it's a flute, and it's got a string instrument as well attached to it. So if at all you have a new instrument or a new technology, whether it's an amplifier, whether it's a new flute or a new string instrument, you can file for a patent. But at the core of moving back to the bucket, which we call it as copyright, it's important for us to understand that what is protected is the creativity. What is respected is the creativity. It's a quid pro quo to the government, where we say we will create and you protect our creativity. So it can be literary work, it can be an artistic work, it can be music, sound recording, cinematograph, film, software. Each of them are completely different. And artistic work is very, very wide, but probably at your, the audience today are looking at more on the musical notations, more on the sound recording, and more on dramatic work, which we will speak about later. Why I say that I love this slide, because it's like a piece of cake, a rainbow cake, because in copyright law, one needs to understand that there are many multiple layers for any given work. So if assuming that there is a dance drama, imagine the number of artists who will be culminating to make it a reality. There would be a person who's writing the script, who will be putting together a music, who will possibly write lyrics for that music, and there'll be possibly dialogues in between who will write. There would be a person who writes the dialogue. There might be a sound engineer who will be recording or playing playback music or background music, or he will be recording the sound recording fully. And then there is a video cinematographer who will probably be, or just a video recording, who does a recording of the entire dance drama. Now, if you were to ask me, there are at least 7 or 8 different individual elements, 7 or 8 different individual creators. Who's going to be the owner is the $1 million question. And most often we get confused. Most often we try to wrap our head around that. And that actually is very simple. You need to understand that every work will have 2 persons involved in it. It can be the same person, or it can be 2 different persons. One is the author. Author is the person who is the creator. So any individual work of art will have a creator or an author. But that author need not necessarily always be the owner, which means if you need to understand whether it's a collaborative work or whether it's a commissioned work, whether you have agreed otherwise between your friends or collaborators. So let's just push this away, and I'll give you a very short example before I give it back to the group. If I were to take a photograph of one of you in a public place, it's so different. But if I am a photographer who is sitting inside a studio, and you come into the studio and ask me to take a passport photo of you, it's different. In the first example where I take a photograph of you with the same camera in a public place, I own the copyright because I am the owner. No one commissioned me. You are in a public place. I am free to shoot you. I have shot you. As long as it's not a private place and it's not invading your privacy. But if you come into my studio and you engage or commission me to take a photograph of you for a special occasion, then you've commissioned me for a particular fee, and I agreed that I will do that for you. And then I will be the author, creator, but you as a person who commissioned me would be the owner. So that's why I keep going back to the cake example. You need to understand if there is a very complicated, work of art like dance drama or a cinematograph film, there will be hundreds or tens and hundreds of artists who will be working in it. You need to understand how they agree between each other, or whether there was normally the producer of the entire gig would own it, unless the creators agree otherwise. So in the example of the J.J. Devi case, which is quite renowned, at least in the copyright world in India, where late Sri Lalgudi Jayaraman was commissioned. I say commissioned because that's how the court interpreted it, by the Cleveland Indian Association for making a dance drama. And there was payment made, but there was no written contract to say that he was commissioned to do the work, that the ownership changed from him to the Cleveland Association. When they wanted to recreate it the next year without his team being involved, without him being involved, he moved the Madras High Court and he got an order in his favor. And the court agreed, yes, you are the creator, Mr. Lalgudi Jayaraman. You created it. They did ask you to come and perform. They did pay you, but the payment was made only for the performance, but not for the transfer of ownership of the creativity. So when we talk about who's the creator, author, who's the owner. There are a lot of factors one needs to keep in mind before we agree who's the dichotomy between the author and owner. So that's very, very critical. And I give it back to Rati and Kritika.
Yeah, thank you. I mean, I think just live in the session now, providing context, we learned so many valuable insights specific to the owner author, the real life scenario, especially in a real life scenario we're also familiar with in this space. Thank you, that was so valuable. When it comes to the strength of copyright versus patent versus trademark, in the process of making the collage our own, or in the process of baking the cake as the colors reveal themselves, if I may, does one afford protection more than the other? So other than ideas, what isn't included in IP protection? So we often hear about stolen content, quote unquote, borrowed choreography, quote unquote, inspired music in our space. But what am I protected by if I register my copyright and protect my IP versus not doing so? Leah, could you expand more? Where does plagiarism fit in the realm of IP?
Yeah, so plagiarism is using someone else's work or ideas without properly giving credit to them, to the original author. And plagiarism does not have any legal significance in US copyright law. So that's different from copyright infringement, which is, like I said, the unlawful use of someone's copyrighted work. So plagiarism goes more into attributing and giving credit to the original author. And copyright goes to enforcing your copyrighted work through the courts.
Gotcha. But does plagiarism even have legal significance in India or outside US, per your knowledge?
Oh, absolutely. I mean, plagiarism is nothing but legally we call it as an infringement. And anyone who uses any work, whether it is for 2 seconds or 2 paragraphs or 20 words, would need permission or consent or license or blessing from the owner of the copyright. So I see a few questions already popping up, whether cover versions need permissions or, of course, yes. There are different types of permissions and consents. So one is mechanical license, one is full license. Anything which is not consented is infringement under copyright law. You can call it plagiarism. You can use multiple words for it. But at the end of the day, it's illegal and it is infringement or it's plagiarism.
Absolutely. Hope that provides us all with some context. I'll turn it back over to Kritika now to begin our next segment.
Awesome. Sorry, I was just trying to unmute myself. All right, so let's start now with the second part of our session, which is going to be applying the law to some case studies. So for this part, Ratipriya and I are going to show you and read through a hypothetical scenario involving many different stakeholders from our creative art space. And during this part, pay close attention and think about the IP issues that you see as a third party. After we read through the scenario, we're going to ask you all to answer an open-ended question and analyze what you think went wrong in the situation. And after that, our lawyers are going to guide us through some additional questions for each scenario. So if you want to refer back to the case study, we have provided them for you in the handout that we mentioned and that we linked in the chats in the YouTube and in the Zoom. So feel free to refer back to that. So with that, let's go ahead and start our first case study, which is, as Bharat was saying, the $1 million question: who owns the IP? So in this case study, a group of artists, a dancer, a musician, a mridangam player, and a violinist, approach a lawyer with an original production they have created together and want to trademark their group name, the Classical Artists Collective. The dancer has choreographed the production, the musician has written the lyrics and set the tune, the mridangam player has set the jatis, and the violinist has helped the musician with the tune. They approach a lawyer to protect their work. So our question to all of you in the Zoom participation is, What, if any, IP protections do you think these artists are going to run into? And putting on your lawyer thinking hat, what do you think the lawyer should think about when he or she is trying to help these artists? So there are no incorrect answers. Feel free to think about it for a minute and then unmute yourself, turn your video on, and let us know what you think about this whole situation and what issues you think are going to come up. And again, there are no wrong answers. So feel free to jump in. All right. So if nobody has any comments, Bharat and Leah can sort of talk about, since they're both faced with this situation very frequently, what sort of things as a lawyer would you both think through in this situation? I guess we can start with Bharat. Oh wait, let's see. Somebody actually said in the chat, maybe co-ownership of IP. That's definitely true because you have multiple stakeholders here. But yeah, absolutely. I think somebody said they think the name is too generic. So we'll talk about that with Leah, whether we think the name is too generic. That's great. Any other comments? All right. So yeah, those are great segues into our questions that we have for both of you. So what are some factors the lawyer is going to consider? And we can start with Bharat if you want to go ahead.
Sure. Firstly, it goes back to who put them all together. Was there a Cleveland Indian Association involved, or was there a production company involved, or was it a natural culmination of these group of friends who came together, or a bunch of persons who are chatting on this YouTube or session can also come together as a group and start their own forum. At the end of the day, we need to know who's in charge of the entire production. There might be individual owners, individual creators, but in a very subjective manner, the lyrics might stand out separately without anyone contributing. The music might stand out without anyone else contributing. The jati is also, in a way, might be so. But when everything comes together, then the dance drama is a culmination of all of it. Now, when each individual creator might own their own layer of that cake, which we were talking about, who owns the whole of the cake is a completely different ask. So normally, the producer means not the financier. There is a difference between a producer and a financier. Producer is the person who takes her or his time, efforts, and time to bring all these together and make them work in the same way and come out with the end result in a manner which is called as a dance drama, right? The entire production. So normally that's the first person who might be the owner. But if all of you agree, as artists, you can do it differently and say, no, this all of it are going to be combined owners as well. So it's quite subjective, but each of you might have your own little layers, but together you need to agree as to who's going to be the owner.
Got it. And so in this concept of agreement, the best way are you saying the best way to do it is for everyone to sort of talk to each other and maybe put it down in writing beforehand so that if there is an issue that comes along later, it's much easier to know who owns each part of the cake, basically?
Absolutely. I mean, if I may use the terminology I would like to use, it's akin to a prenuptial agreement. Because when you are dating and you're seeing each other, everything is good. When you get married, everything is good. But everyone looks at the agreement only when it's time to part ways or when you start differing with each other or when you want to commercialize the product and make revenues out of it. So why I call it prenuptial agreement is it's always good to write things in paper and sign off and agree when things are good. Most 99% of the agreements between parties are looked back into only when there is a problem. Until there is a problem, no one looks at what we agreed on. But if you don't have an agreement and then you end up on a problem, you have nothing to fall back on and everything will be tearing it apart. So shortly put, an agreement is good when the going is good.
Yeah. And many of the collaborators in our Indian art space, they often tend to be friends. And I think that concept of friendship is what deters so many stakeholders in the space from entering into an agreement in the first place. So obviously, everyone should enter into an agreement. I think we've all heard it from you. But in the event that they're just not able to get themselves to enter into an agreement, what is the best fallback that they can do to sort of make sure that these things are memorialized in some way so that if something comes up, they're able to fall back on it and able to resolve it?
Well, I'm a bit traditional when it comes to that. I mean, I would first prefer to have a written agreement and sign. You and I know how these, when it reaches the court will tear it apart and how evidence is led. But if you don't have the patience or the time and all the luxury of meeting a lawyer or drawing up an agreement and then signing all of it, at least exchange emails between each other, not WhatsApp. I don't like WhatsApp. I don't like SMS. I don't like telegrams, but at least an email, if not official, at least personal emails on what is what. So a round of discussion, someone should take the minutes of discussions. Someone should take the ownership of these are the 10 things which we agreed on. These are, even though we don't have a written agreement, this is what the go-to document is. So that's a fallback net, and that's a safety net I'm talking about. But that's not a great way. It's an okay way, but it's only a safety net.
Yeah, no, that totally makes sense. So for any creatives listening, define your art the way that you want to define it in an agreement, and don't let a court interpret what your art means for you. I think that's the bottom line. And I think that also lends itself well to the answer to the third bullet point we have here is if an artist leaves the group, if you have an agreement in place, that will sort of shield you a little bit better. So something that I want, yes, Bharat, go ahead.
I'm sorry, before I forget, it just occurred to me on the go that when we are all assembled here, we all agreed to the terms and conditions of Zoom and YouTube. You didn't know that you agreed, but you just clicked the button and I said accept and agree. They will do the rest, but they were like a 20-page document you signed to come on here. So if you can do that to come and attend the session, I'm sure that you can take some more time to drop your own agreements.
Absolutely. That totally makes sense. That little check that we always do when downloading an app, or that's drafted many long hours by a lawyer. So you're not just agreeing to blanket statements. So that totally makes sense. And Leah, I want to talk to you a little bit. Somebody had put in the chat that they think that this name is too generic to be trademarkable. So can you speak to that a little bit?
Yes, they were definitely in the right path. For the lawyer here, they would first determine what is this group coming in for? What are their goods and services that they are providing? So if that is sound recordings, it sounds like it's going to be musical live performances. You would have to determine if this name, the Classical Artists Collective, is descriptive in the nature of that goods or service that they're providing. So for this, for example, it doesn't have any trademark significance. Classical could be maybe the genre of the music. Artist is exactly what they are. That would be a generic term. And collective is a very commonly used name that has no source identifying information. So in this case, it would be a very weak trademark and have little to no trademark protection.
So in your opinion, what are the consequences of having a weak trademark like this? And how could this group strengthen their trademark in this case?
Sure. So they could strengthen it by probably not having anything that is descriptive of the goods. So maybe making up a name, something that is completely arbitrary in the context of their goods and services. It's just something random that has no connection. That would be one. And the second one, they wouldn't have any federal protections. So the trademark office would most likely, because this name is very weak, they would not grant them the trademark. And then they wouldn't have protections to enforce their trademark. They can't sue anyone if someone was using the same name.
Got it. That makes sense. And I guess, but you were mentioning something about Indosol. So Leah, like a name like Indosol, because it's sort of distinctive and unique and doesn't have any generic terminology, that would be an example of something that a court would likely grant a trademark because of how unique it is.
Yes. And if something is not generic, but it's maybe slightly descriptive, there is something called acquired distinctiveness. So if at first the mark is not distinctive, but they could be on the supplemental register. So they could basically, it's like a holding period. And if they're using their mark in commerce for at least, generally it's about 5 years, they can acquire distinctiveness through their use. And after about 5 years, then they could be registered on the trademark registry.
Got it.
Yep.
That's very helpful to know. So I guess for the takeaways for this session, 2 that I have already is get everything down in writing. And for any creatives, make sure that you define your art the way that you want to define it, so someone else doesn't define it for you later on. And the second thing with regard to trademarks that I've taken away is that basically make sure that whatever name you come up with is as unique and as distinctive as possible so that the court will give you a trademark and that you're not in a holding period or something like that, so you can start commercializing and developing your brand as quickly as possible. Do either of you have anything else to add to that before we go on to the next one? Awesome. So Ratipriya, I'll let you take it away for the second case study.
All right. So I think that free-flowing creativity and fair use source of truth that Bharat and Leah spoke into is exactly what made us essay the second case study. And to present the second case study, the group in case study 1 asks a graphic designer to help them with social media PR collateral. The designer sees the portfolio of a highly acclaimed artist in the field with lots of followers. She screenshots her favorite posts for inspiration. After studying each screenshot, she exports one of the completed compositions into her design file, changes the color, and presents it for critique in her next review. So bottom line question, is this plagiarism? Any of our participants, please feel free to unmute, raise your hand, turn your video on, feel free to participate. So bottom line question before we analyze it, is this plagiarism?
Yes.
Yes. Bottom line answer. And also, yes, thank you. And also, maybe we could start to think through what the designer could have done better in her creative process, how we kind of start to originate the final work to make it our own, to Leah's points from the beginning, giving us context, and maybe what the reviewers could have done to recognize the original work. So Leah, I'll start with you. Where all could you catch that this was happening, that plagiarism was happening from the case study?
Yes, I believe it says that she felt inspired, but in reaction to that, she screenshotted directly that work. And that direct screenshot is a direct copy, and that would be plagiarism. That's the first claim. The second would, she did change the color, but changing the color it wouldn't fall under the fair use exception because that's not transforming the work. That's not adding some creative and original meaning. Changing the color is not original, unless you invented the color, but I don't think so in that case. So those are the 2 things. That is just a direct copy, and it would not fall under the fair use exception here.
Absolutely. And Bharat, could you speak into context of where all the violations took place? Yes, it started with that screenshot, but what more we could have done after that point or at that point to avoid further IP violation for plagiarism?
Well, the group can obviously realize that it's a very accomplished artist who would be more having much better access to an IP lawyer. So they would definitely come after you or the group. Besides that, since we're all here in the creative world, respecting each other's boundaries, and I go back to the example of the property and the fencing you have or the wall around your property. As long as you keep your property safe, sound, secure, clean, it's equally important that you don't park your car in someone else's garage, right? Absolutely. So whether it is for what this person has done is taken a screenshot, as Leah said, screenshotting itself is first violation. Altering it without much change is also a violation. But it's not yet put into a public domain. So as a group, when it's presented to me, if I'm a member of the group, the collective group, I would, as a good Samaritan, raise my hand and say, enough's enough. I know this person. I don't want to copy them. So even though it's only for a PR activity, right? Yes. That's great publicity, but bad publicity.
Yes, absolutely agree. And I hope our panelists are resonating with this context. I know we have many creatives here who are in the fine arts associated background from the space. So this definitely is lived experience for all of us. Misconduct, it just proves that misconduct can take many forms, right? And can stem from discomfort in a general sense. When we think of misconduct, we often think of sexual misconduct that occurred in Me Too movement. But as you can see here, it can begin at any stage of the creative process or any stage of due process. So screenshot with care and give your credit where necessary. Any other takeaways that we'd like to speak into from this case study?
Quick to add is that just giving parenthood or credit doesn't undo the wrong. So just because I've screenshotted and then I give courtesy so and so does not make it any less illegal. It's just that you are acknowledging the source is not making it legal. Yes. You will make it legal by taking a consent license or a permit or a blessing, but that does so acknowledgement or giving credits does not absolve you of any liability.
Absolutely. And go ahead.
I had a follow-up question actually on that, because I remember, so this concept of like intent or being malicious, or in some contexts it can relieve you of liability when you don't mean to do something. And I think in our space it's really important to highlight this, because often we all just want to be creative, we all love each other, we all love taking inspiration, and the intent a lot of the time isn't to do this on purpose. So does the fact that you're purposefully doing something, or you didn't have a malicious intent to do it, does that relieve you of liability in any way in the context of IP, or does what you meant to do not matter? And either of you can take this. I was just curious because you talked about the fact that it's wrong no matter what. So I was curious.
Well, the intent will come in only possibly in terms of how much damages you need to give. But it doesn't absolve you of liability. So instead of paying $10 million, you didn't have the intent, you'll probably pay $1 million, right? So that's for the jury to in a US soil, for us to convince the jury that I didn't have bad intent. But on Indian soil, intention doesn't really matter in a copyright violation.
Absolutely. And that being said, there's also plenty of ways to accurately integrate your work inspiration that you find, and given assets, given style guides and books of code to integrate into your actual work to make it original and make it your own. If anybody has a question about that, feel free to post it in either chat and we'll address it at the end for some of the resources you could follow. I saw a couple people unmute. Was there anything else someone wanted to speak into? Does uploading your work to social media affect your creative ownership? So I think we spoke to that a little bit. Bharat, would you like to expand on that? Does uploading your work to social media affect your creative ownership?
Not really. I mean, it's easier way to publish instantly, and it's easier way to showcase your work to the world. As I said in copyright, the minute it is created, whether you upload it or you publish it or not, doesn't really matter. The deep root of the matter is, are you the original? Is the work original, as Leah said originally? Is the work original, and are you the creator of that original work? Those are the only two things which matter. Whether you keep it on a tape, whether you keep it on a CD, whether you make it as an MP3 audio or an MP4 video, or you upload it on YouTube or any of the OTT channels or the new medium doesn't really matter. It has to be in a tangible form, yes, as Leah said, but whether it's YouTube or Facebook or your own webcast page, whether you have your own channel or website, it doesn't really matter.
Absolutely. And Leah, did you want to speak to fair use in this kind of scenario? Like, what would be considered fair use in this case?
Yes, and I was also going to say in the US, it doesn't matter about uploading to social media if you are a registered copyright owner, because it doesn't change the ownership, because you are still registered as the owner for that copyright. So you could feel free to share it in any form that you would like. And for a fair use, for the last case, is that what you're referencing to?
For this particular designer screenshotting.
Yep. So maybe just, first of all, not screenshotting. Maybe if she looked at whatever she was interested in, and if she did have some form of inspiration, just adding some original ideas to that work, something that will change that maybe meaning or message or context of what was inspired by her. Another way, she could have reached out to the original author or artist in this case, and maybe asked for a license to use it if that's what she wanted to do, because you could also, owners could license their work to other people, which is giving them some type of temporary grant to use their work, but with permission.
Very helpful. I see a hand raised from our workshop participant. Would you like to go ahead and contribute?
Yeah, I just had a quick question of authorship versus ownership. So in the example of social media, we talk about it even for the Zoom recording. We hit continue and we've agreed to something, and I'm sure I haven't read the 20 pages that I agreed to. So for social media, is it possible that we sign those same type of agreements, and in that agreement it says that by engaging in this platform, everything you post is owned by the media platform itself, as opposed to the person writing? I think it's kind of the same type of question of, let's say you work for a company and you invent something. I think there's some idea that the company owns that IP, even though you are the inventor. So should we be reading into the fine lines more? Is there some general protection, fair use kind of considerations there?
I'm seeing affirmative head nods. Leah, why don't you go first?
I was nodding in regards to the contracts that we sign that we don't actually read. I don't know anyone who will sit through those contracts. You just say, accept terms of conditions. And for example, for Instagram, they do have a clause in there that says they do own the rights to the things that you post in some form. But I think the ownership versus authorship, my co-panelist is an expert in this field, so he could talk a lot more about that.
Absolutely. Take it away, Bud.
Oh, so I'll answer the second question first, because that's very, very, very important. I'm glad that question came up. Thanks, PD. if you are employee of a corporation and you are creating something during the course of your employment, by virtue of you being employed, I'm sorry, I'm using a lot of legal jargon. When you are an employee in a company and during the course of employment, if you're creating something, the company owns it normally, unless your employment contract gives you the liberty to own something on your own. So if you are using office time, office resource, office computer, office equipment, and you are creating something for the corporation during the course of employment, the corporation owns it all. I mean, that's at least the law in India. And I'm sure it's almost the same in the US as well. So that's almost the same as what you do with most of the social media, that if you upload your creativity to, say, YouTube or Instagram, the rules which they set on you, they would have in those 20 pages, 300 paragraphs, would have possibly asked everything under the sun to do, to give away your consent and permission to do whatever they want. So it's your choice whether you want to upload that photograph of yours that they can reuse or repost, or whether it's critique or fair dealing or not. They would have. I mean, I'm not criticizing them, because we voluntarily sign up and upload what we want to upload. So take that extra time to understand what these are. I still know persons who don't go on Android sites. So one end of the spectrum is Google, which asks for anything and everything in open source, and everything is free for everyone to see. And the other end of the spectrum is Apple, which respects privacy, and everything you do, you need to know what happens there. So I only say, whether it's 200 pages or 20 pages or 200 paragraphs, you need to read the fine print. While lawyers are doing their jobs, you also sign contracts on an everyday basis. Every time you download an app, every time you go on a social media, every time you volunteer to do something, and the hurry, you just sign up and go, that's what you do. So you give your data, you give your consent. Once you have given a consent, we can't be cribbing about it.
Absolutely. Thank you so much. I think this nicely lends way to our next case study, which presents the organizer's dilemma. So I'd like to reiterate, we're not trying to limit your creativity, but we're trying to enable it by protecting the IP of it. So the organizer now, from case study 1, would like to market the production and bring that group of artists to perform under their organization. So main question, what, if any, IP considerations should the organizer think about and discuss with the group of artists? So kind of putting our stakeholder approach hat on to apply now. So what kinds of IP considerations should we be encouraging the organizer to think through? Feel free to unmute, feel free to raise your hand. Unless anyone has something to contribute, we can start to analyze it a bit and talk through commissioning of the work, the distribution rights. What if one person from the organization leaves? What's the protocol for transferring IP? What if somebody from the organization wants to video record the performance? How does selling a video recording work? Who owns that IP then? Bharat, would you like to speak into the IP ownership in this scenario, and maybe the thought process that the organizer should make sure he takes? I know we spoke briefly before to agreements, WhatsApp or not, making sure that they exist, making sure that at least verbal agreements exist, but could you expand on that?
So it depends on who hires me.
Mm-hmm.
Is it the organizer who's going to hire me, or is it going to be the performing group which is going to hire me? So that's what lawyers do, and that's what agreements are for. If I'm part of if as a lawyer I'm called upon to represent the group, I will not let them give away any of these rights unless they consent for a due consideration, whether it's royalty or a specific time period, specific geography, specific medium. On behalf of the performing artists and performing group and the producer, I would try to restrict as much as possible so that I would have them the maximum benefit of monetizing it as and when they need to. But if the organizer were to approach me, I don't know if some organizers are here in the audience, I would have obviously spent a lot of money and time in commissioning this entire production. So if this was not a preconceived idea or a notation or a work which was already pieced together, and if I'm paying money for a particular producer or a senior artist to say, you put together 20 artists, this is the broad theme, you get it done, I don't know what happens, you please get this done for me. As a organizer or a person or as a lawyer, representing the organizer, I will try to take all the rights because it's a commissioned work. This is the same example I gave you of a photographer, camera, and a subject person, whether you are inside the studio or outside the studio. So very quick analogy. Netflix or other OTT platforms, whether you are in India like Voot or they have original series and then they have licensed series. Like Amazon is enabling others like YouTube to come and upload their own content. But if there are original series, it means Netflix is not going to go and shoot the entire episodes or all the content. They are going to go to a content acquiring company, and the content acquiring company will scout for producer, writer, script writer, cinematographer, artists, light boy, everyone. So, but Netflix at the end of the day will take it all because they can't run the risk of not taking rights and then be sued later. Because it's very easy for the organizer to be sued for every shortcoming. So from an organizer's perspective, it's better to take as much rights as possible. From a creative set, you need to know whether you are commissioned or not.
Absolutely. Any other takeaways, Leah, that you're able to speak into in terms of transferring distribution rights, or if there's a naming change that happens, how to make sure that that's protected from the organizer's perspective?
Yes, I think everything was generally covered. What I wanted to talk about was just the context of everything boils down to what has been negotiated between the parties and what is contracted to. So the price, what is going to be licensed, if there is a licensing agreement for the IP that is owned, generally how long they would have those rights, so the time period and what context, if that is the recording, if they're going to be selling merchandise, who gets the money for the merchandise, who gets the money for the recordings and everything that is sold and the profits. So, but that will all be negotiated, and that's just things to consider.
Wonderful. I'm going to turn it over to Kritika now for our fourth and final case study.
Awesome. So this last case study is something that is especially relevant for all of us because we're living in a digital world right now, especially with the pandemic and everything being on virtual platforms. So this one, I'm just going to click so we can see it. Awesome. So a YouTube artist sees a performance of the production from the first case study that we've been talking about and feels, quote unquote, inspired. The artist records the production when she attends and goes home to choreograph her own piece. She refers to the video for inspiration, but copies an entire segment of choreography from the production. She performs it all over and posts it to her YouTube channel, fails to give credit to the original production, and does not obtain permission from the original artist. So now, as bystanders, as all of us, bystanders are also a key stakeholder in this space, right? We are perceiving these things and we have, the power to sort of see the misconduct and do something about it. So what steps should a channel subscriber take to report this issue? If they see that, hey, they recognize the production or they recognize the choreography, what do you all think that this particular person should do? And you can unmute yourself, put it in the chat, whatever you feel comfortable with. And once you guys sort of chime in, Leah and Bharat will sort of talk about what is possible in this situation, because it might be difficult to think about what can actually be done in this situation.
Well, couldn't you first ask for them to take it down?
Yeah, that's a great thought. You could ask them to take it down. I guess the artist or a bystander could ask them to take it down. Someone also said, I would flag it and get in touch with the person, report it to YouTube. We'll talk about that a little bit. Educate the YouTube artist about imitation. That's great. Now that you're all equipped with those tools, you can absolutely do that. Yeah, these are all great thoughts. So the first thing I want to talk about is, if we can go to the next slide real quick. I think I may have lost remote control access to the slide. Thank you. So what should the YouTube artist have done differently here? The medium of publication, like whether they put it on YouTube or Instagram. I know Leah talked a little bit about this before, but that you're agreeing to different terms on every platform you post. Who can actually report this? I mean, that's a big question here that a lot of people have talked about. A lot of them want to report it themselves. Is that even possible? And the last thing I want you both to talk about is sort of, if this was a student and like a minor, someone who can't even enter into a contract legally because they're under the age of 18, what happens if they were under the influence of a teacher? And who would be responsible in a potential IP lawsuit? So I guess, Leah, we can start off with you in sort of what they could have done differently here and what the protocol would be for reporting this.
Yeah, so if they were posted to YouTube, the protocol for YouTube would be a takedown notice. But in order to file a takedown notice directly in YouTube, there's a specific portal where you could go to file this complaint. You need to be the actual owner of the copyright. So you could try to get in touch with the owner of the copyright and maybe let them know that their work is out there and they could contact YouTube. The YouTube usually has an algorithm that catches copyrighted work before it's actually posted. So if the music is copyrighted, if this is a dance and there's copyrighted music, usually YouTube will not even allow the user to post it. But sometimes it doesn't catch everything, and an owner could go in and just file a complaint directly with YouTube to take it down. The YouTube artist itself who posted it, they could have gave credit to the original artist, maybe asked for a license to use their work if it is a musical sound recording. But as my co-panelist said before, just giving credit is not, doesn't take you out of the realm of copyright infringement or copying. It's still a copy.
Okay. And Bharat, if you could talk a little bit about this concept of a student under the influence of a teacher, I'm really curious about that, because this isn't something that's uncommon in our space, where, teachers are sort of taking inspiration from different videos online. There's a wealth of knowledge online now, and it's only natural for them to want to use that. But what would happen in the situation if someone were to report it and they would realize that that the copyright is infringed? And can you sort of walk us through what would happen to the student in that case?
Well, first question is the student of legal adulthood age, whether he or she is capable of being sued or being liable for the infringement. Whether she or he was under the influence of a teacher is not going to take away the primary liability of an infringement, right? So the parallel example I would give is if there is 10 books of Harry Potter and there is J.K. Rowling, and you've gone to second book, third chapter, and taken 5 paragraphs out of it. You've taken entirely that 5 paragraphs after chapter 2 of book 3 of J.K. Rowling. Even those 3 paragraphs are good enough for you to claim plagiarism for her, right? So similarly here, the YouTube artist had no business firstly shooting the video, because the first violation is shooting without permission. Because the biggest problem we have even in Chennai, in India, rather not just in Chennai, is the various Carnatic singers and performers and artists who come and say during the season in December, January, there are persons who just yank out their phones and start recording audios, and then they go back and start having a repertoire of the songs, which is crazy. That's precisely what has happened here in this case study. Firstly, the recording itself is the first infringement. Going back and recreating is the second infringement. And third is to give us or give the earlier, the entire group an easy evidence by uploading it onto the YouTube is easy to take. So a takedown can only be possible by the right owner, not by anyone else. So if you see someone else entering a third person's house, you can't be a whistleblower in YouTube, you know. So you need to call the owner and tell them that there is someone breaking into your house, and that's about it.
Yeah. So I think that leads nicely into our takeaways for this particular case study. And what I've learned from this is that the violation can take many different forms, right? We often think that it's only the produced product that is the actual violation. But as we learned from case study 2, it can happen at the screenshot, the very first action that you take. It happens here in this one, right when they're recording the performance without any permission. And make sure that because the owner of the copyright is really the only one that can report it and can file a complaint about it, make sure that if you're a bystander in this situation, that you really try to get in touch with that person, because they're really the only person in the best position to do something about it. Is there anything else that I missed? Awesome. So with that, I'm going to hand it over to Ratipriya to sort of talk about the practical takeaways that we want from this session, and then I'll circle back with you all with some of your questions from the session.
Thanks, Krith. Yes, so we'll take the last few minutes we have in our workshop today to address final takeaways and Q&A. Just make sure at this time that you type in any questions that you have in the Zoom and YouTube chat. Please be advised that while our panelists are experts in their respective fields, they won't be able to answer any questions pertaining to specific scenarios or give opinions or legal advice around your specific situation. So please refrain from using actual names of people, actual names of organizations or other entities, but provide as much detail as you can so that we can give the panelists the appropriate context. So Bharat and Leah have highlighted the key importance of needing to protect IP and its surrounding nuance. Most of you are now probably thinking that you want to find a way to protect your IP, and it's probably inspired all of us to consider accessibility and begin to think about what we need to equip ourselves to handle scenarios like this ethically. So we thought that we would provide these takeaways as some common questions that we often hear when we decide that we need legal help. So those common questions include things like knowing when I need a lawyer, knowing what I need to bring to a meeting with a lawyer, and in terms of accessibility, what are the flexible things available to me in terms of budget or pro bono cost? And in our virtual world today, living in the pandemic world, what are some best practices that we can kind of follow when we post content or we're doing covers of other artists' work? Bharat, would you like to start? What are some ways that we can start to consider this for ourselves?
Well, you may not like this, but doctors and lawyers are always needed. It's just that as much as self-medication is bad, over-the-counter medications are also equally crazy. Is how I view as trying to guesstimate what law is or what legal advice or assumptions are. So by that logic, when in doubt, ask a lawyer. Not all lawyers charge. A lot of pro bono legal clinic helps happen. I'm sure Kritika's office firm, which is quite large, does a lot of pro bono work. Most of us don't, at least on Indian soil, don't charge for the initial queries or most of the queries unless you were to ask the lawyer to spend their quality time to start drafting something for you. So you don't have to be scared about lawyers. Those days are gone when they say that I charge $300 for 3 questions. What is your second and third question?
Mm-hmm. And Leah, in your experience, what are some things that you would love to see people come prepared with when they come to you for that first consultation or first meeting?
They would have to bring copies of what they would like to trademark or copyright, the purpose, their use, what are they using it for in connection, with whatever they are providing. I see a question about, and specifically for dancers and their choreography, in pertaining to the tangibility of dances. Recording a dance is putting it into a tangible form. So that would be an acceptable form. And that's usually how dancers put their copyrighted work into a tangible form. You could also annotate it, but video is the most common way.
Awesome. Thanks for addressing. Yeah, I was going to ask you that next. Perfect. Hope that answered your question. And yeah, basic takeaway is personalize everything to how you want to originate the work, transform it. Anything else that you both would like to speak into in terms of tangible takeaways for how we can equip ourselves and make IP more accessible to us? Otherwise, go for it.
No, I'll take the last point first. I mean, which is there on the screen. Yep. It's no different in the virtual world. It's just that it's a new medium and the rules of the game are the same. They're not going to change just because it's virtual. And so when in doubt, don't use it. When you don't know who where the source is or who the original owner or the author is, take that extra mile. And when in doubt, one last point is absolutely important we didn't cover, is that what is available in public domain is not free for use. When I say available in public domain, if you find something online, just because it is available online and in a public domain does not mean that it is meant for public free use. So I can't right-click copy and use it, or I can't use a YouTube downloader to use it. So that's a very, very critical mistake a lot of persons feel. Oh, it's there on the internet, it's free to use. That's something which you need to understand, that whether it's on Instagram, whether it's on Facebook or any medium for that matter, because it's available or it's put up for viewership by the owner or the author or the content provider, doesn't mean that it's free for you to use.
Right, absolutely. And that was one of the points around case study 2, is that because it's free to use doesn't mean that it's correct to completely take it away with the screenshot. And there are proper forms of integration of that work as well that exist as guidelines. They are provided to be used as templates and not considered stealing at that point. Thank you so much. I think with that, we can pretty much start the Q&A portion of our session today. Thank you. And I see a hand raised from a workshop participant. Did you have something else to speak into? I think it's Ravi.
Oh yeah, hi. Yeah, thanks for this. It was really interesting. I was just wondering in general, so we talked about like dance choreography, for example, with copyright. I find like a lot of the time, a lot of these compositions and stuff are like traditional, right? So, some guru a long time ago composed it, or even somebody nowadays plays it in a specific way. Like I can give an example, like as a tabla player, we have like different gharanas, right? So somebody will play something one way, and maybe like you said with YouTube, another player might kind of see that on YouTube and try to play what they did, right? But I feel like there's kind of a gray zone, because you can't really say, like, is that copyright or not? It's just like I might see it and like, okay, they're kind of playing it wrong, but like it's not I don't know, copyright? Because I just thought, because we gave the dance example, I'm just wondering if that's like anybody has realized that with maybe instrumental or even vocal, because traditional ways you just say the composer, or like even a lot of the songs, it could be any kind of poetry or bhajan, even like you say the composer's name, right? So that's like the original, the OG way of like giving out, I guess, the copyright issue. So back then nobody would sign any documents, right? So I was just wondering if you guys have any comments on that, because like I don't know, I've noticed it, and like I'm not really sure if when it's like actual copyright or not. Yeah, I don't know, it's kind of a long question.
Yeah, I'll shortly answer it, Ravi. It's very simple. Copyright exists for 60 years in Indian soil after the author dies, right? So it's for the entire lifetime plus 60 years. So if there is a OG song which was created in the 1920s and the creator or author dies in the 30s, and the copyright would have extended for 1990, right? So the whole benefit of this 60 years after the lifetime of an author is for the next generation to benefit in the very, very traditional world, right? I'm not talking about the production companies and record label companies. So if there is a big artist or a singer or a composer, like the estate of Michael Jackson is earning more money now than during his lifetime by taking out licenses and collecting royalties. So what I'm trying to say is, once the 60 years period is over, it comes into the public domain for anyone to do anything with that content. But if you were to sing happy birthday to you in Aditalam or some new ragam, then you are putting a new spin to the entire happy birthday, which possibly right now is, I don't know the birth or the creative date for happy birthday to you. But if you take your own spin on a content which is already in public domain out of copyright regime, then you can possibly claim it to be a new content which you have created originally. So the tabla example which you gave, possibly that notation for that particular original piece of a 1 hour performance, if 10 minutes is something unique, then they can claim creative ownership over that particular piece, which is unique to them.
Yeah, that's a great question. And thank you so much, Bharat, for laying that out for us. I think another thing that I also thought of when you were talking about this is a lot of artists in our space write no copyright infringement intended in literally everything that they post. And if I understood the session correctly, based on everything that you both have said, it's that really has no effect on whether or not you're actually infringing on something. I think I want you both to sort of talk about that. And then this concept that just because something is in the public domain, I think that's a misunderstood concept. Like, public domain doesn't necessarily mean that something is just out there in the public. It has to have some time that needs to have elapsed, if I'm understanding that correctly. If you both can sort of talk about that.
Yeah, I think providing a disclaimer is morally correct and maybe ethically correct, and it is the right thing to do, but it doesn't take it out of the context. If you are completely copying someone else's work, it is still a copy. It doesn't take it out, but it is nice to attribute the original author, but you're still stealing their original work.
Yeah. I have a really interesting question that one of the participants asked, and it's, my teacher uses recordings online to teach Manodharmam improv. Is that a violation of creative IP if used for learning purposes? And does that change if I then use the same improv in my performance? So, Bharat, if you want to take this one.
Just repeat that. Sorry, I missed it.
Sure.
I was trying to read some other question on the chat. I missed the question. Sorry.
No problem. No problem. My teacher uses recordings online to teach Manodharmam, or improvisation. Is that a violation of creative IP if used for learning purposes? And does that change if I then use the same improv in my performance? And I can give you more context if you need it, but that's the basic question.
Yeah, these are very, very subjective, extremely subjective, because as I say, every creative person would create something based on their upbringing, experience, exposure, cultural, exposure, and so the creativity. So there is a difference between originality and originality means it originates from me. Doesn't mean that it should not sound similar or be closer to already existing work of art, right? So if there is a photograph of a volcanic eruption, and it becomes the cover page of National Geographic, and I take the same photograph and start painting it, I might be inspired by the photograph on the National Geographic cover, but I've been inspired, of course, but it's absolutely new content, because I have not taken a photograph of the photograph. I have not taken a screenshot of the photograph, but I've painted the same photograph of my own efforts. So when you talk about improvs, it's quite subjective unless we know how much of the improv has taken it away from the original work is important to understand. But it's very, very subjective.
Okay. And Leah, I want to direct this question to you. With regards to fair use, how does it generally impact covers of songs or even covers of dances, right? That's been very common in this pandemic environment. People are sort of doing covers of different things. If a musician covers a classic song, can they monetize it, or do they need permission from the original artist?
So to record and distribute a cover of a song, you would need to get permission from the copyright owner. It's not considered fair use when you're doing a cover of a copyrighted work. Even though you're singing the song, it still doesn't fall under that category specifically for covers.
Okay, that's very helpful.
I think what also we didn't go over is something that's considered when you're analyzing fair use is the effect that it has on the market value. So if it's taking away basically money from the original copyright owner, that won't let it fall under fair use. So that's something like if you have a whole entire album of like Beyonce's album in your YouTube videos, if someone could just go onto YouTube and then listen to her album instead of purchasing her album, that would be considered a copy, and it would be unlawful and illegal.
Yeah, I'm so happy you said that, because I think I've seen, especially in our Indian art space, the same version of the same song by the same video or same audio clipping so many times because people have reposted it. So I'm really happy that you highlighted that, because that's very problematic, because the original artist, you're right, it takes away from their viewership, takes away from their subscribers. So that's really important. So thank you for that. Another question that somebody had, and I think, Bharat, you touched on this a little bit in the organizer case study and also with JJ Devi, but I guess they are looking for more guidance in this area. Some dancers usually have our compositions created through financing and commissions. How can ownership be worked out between an artist and another commercial entity? And what if that commercial entity is like a production house rather than a person? And how can they ensure their work is being respected and that they receive the credit for their work? I have a feeling you're going to talk about agreements, but I don't want to be presumptuous.
No, not at all. I mean, whenever there is a production house and it's an agreement, invariably they take away all the rights. But there is something called a moral right. Moral right is something which cannot be taken away from you forever. So if the work is commissioned by the production house and they pay for it and they are the owner, they are the first owner, you are the creator. And they assume that they sell it off to Sony or they sell it off to Netflix, right? Even if it goes to Netflix as a second owner or a third owner or a fourth owner, still your moral rights will still be with you. The moral rights include right to parenthood, right to proper handling of the work. So I'll give you a quick example of what happened in India, which is a very famous case of one sculptor called Amarnath Sehgal. You can go look it up also. It's a very celebrated case where the Indian government had commissioned the sculptor to make a mural to be kept outside the Indian Parliament entrance. And it was a celebrated sculptor, the work of art. Once a few years went by, governments changed. They didn't understand what it was commissioned for. It went into one corner of a room. From one room, it went into a storeroom. And then the sculptor artist got to know that it was being ill-treated or mistreated, and it was not kept in the manner it was originally meant it to be kept. So he filed a case against the government of India, the central government of India, the federal government, and won the case. And so much so that the government in power then said, we no longer want this, but that is their own problem. But the physical possession of that work of art was given back to him because the government said, yes, we paid you money. I had the physical possession of it. I don't need it anymore, so give it back. So even though he did not have the physical ownership, so there is a moral right of parenthood to treat your work properly, which is different from ownership of the physical asset. So the moral right will always be there with you, and to have the work treated well as well.
Okay, that's really helpful. I think we have a hand raised by one of our workshop participants. So I think it was PD. So if you want to go ahead and ask your question right now, go for it.
Yeah, I just had a question about this idea. I think you guys have done an excellent job talking about protecting IP. And then, of course, there's the flip side to that, which is defending it. And I think there's this notion that defending it can be expensive. I think it was alluded to. So I could very well imagine a scenario where you protect your IP very well, but you're not capable of defending it against people who are necessarily infringing on it. So at some point, what it comes down to is not that you didn't protect it, it's just you couldn't defend it, so it didn't mean much, right? So I think the first question is that kind of financial barrier. I was thinking more like traditionally we hear like companies are too big to fail and things like that. I think the idea there is like, even if they have infringed on IP, a small company can never do anything about it. I know this is outside of the idea of artists, but that's the first question. How do we deal with this money power ramification on even if you've protected it so well, you can't defend it? The second question was the idea of the moral question, maybe a little bit different. So maybe I can ask that second if we have time.
In regards to your first question, there are different avenues that you could take. For example, you could go and register for a clinic or apply to a clinic, which would help you. They are student attorneys if you're doing it through a law school at a very small discounted rate in comparison if you wanted to hire an independent lawyer by yourself. And depending on which clinic you choose, they can take you all the way through and represent you in court. And for copyright, patents, trademarks, there's different clinics at different law schools. There's also attorneys at law firms that do pro bono work. So those are different options that you could take if you don't have the financial resources to hire representation independently.
I just also wanted to add that there are organizations, at least in the US, called Volunteer Lawyers for the Arts. Basically, like every major city has a branch of or some of this, and find out where they're located by a simple Google search or going to a local bar association, and they'll point you in that direction. And they're typically lawyers that specifically represent creatives, and they do it on a pro bono basis. So they're all very, very good lawyers. Like they're not volunteer attorneys. They're like actual registered nonprofits that specifically represent artists. So those are great ways to save costs as well. And did you want to ask your second question, PD? I know you had one more.
Sure. Yeah, so this is a little bit lighter. I don't know if you guys know the famous Star Wars theme. Of course, it's like the opening theme. I don't know if you know the first 4 notes of that. It's a direct copy from a composer from the early 20th century. And I think most people don't necessarily know that. And I think it's a transformation, so it's probably fair use, but there's something that kind of bothers me inherently about it, which is it's almost like the original author that the work was inspired from is kind of never got credit for it. So yeah, you didn't violate anything, I mean, necessarily, or at least maybe you could argue it in court, but nobody's bothered. So how do you handle that? I mean, isn't there something, doesn't it feel like there's some human element to it where they should at least give some sort of acknowledgement to that, even if it's not a lawsuit? I mean, isn't there a human element to it?
Well, such a successful franchise, I'm sure they did their homework. Probably it's not running in the titles, but they would have definitely gone back and did a acquisition or a permission or a consent. I presume so. Otherwise, I'm sure in a American society which is quite litigious, and they're not shy to go to the courts or shoot a legal notice through a established lawyer or through the clinics which Leah was mentioning, it would have been blown out of proportions until now.
Thank you so
right,
much.
So I think I think it was fair use, right? I think it's just one of those scenarios where is there any onus to give credit, even if it is fair use, or is there just not kind of that idea? Because I could imagine it takes away from the popularity of the original kind of source of the inspiration, right? So I know maybe it has financial implications, maybe it doesn't, but.
Yeah, so it goes back to whether the author of the original song from the 20th century died 60 years before Star Wars was created.
Yeah. Okay, yeah. No, it's helping. Thank you so much.
Awesome. Maybe we can take the last couple questions for our Q&A segment before we wrap up.
Yeah, I like to address the questions that are coming in live too, because that means that our participants are thinking about them. So this one goes to you, Bharat. What are the steps a dancer could take against infringement and plagiarism of their work, which they put out on social media for viewership? And I guess that goes for, really any type of creative in this space. If they're putting it out on social media, if you have like 3 or 4 tips that they can checkbox before they do that, that would be great.
Assertion of copyright and assertion of your proprietary right is important ahead of the role or after the role. When I say role of that work on the media, so you can possibly spend I don't know whether you've seen in most movies, whether it's Indian or in the US, they have a copyright notice which always comes across. So the US federal government makes it mandatory that every movie has the copyright notice up in the front, and it says that whoever is the owner will assert their rights should there be any parts of this movie to be replicated or copied. So whether you get it registered or not, whether you want to enforce it against third parties, then you get a registration. Then you need a registration. Whether you register or not, assert your rights and spend about 5 to 10 seconds asserting that rights. Give sufficient time for that copyright notice to be read compulsorily by persons at the start and at the finish as well, and have a ticker or a footer somewhere to say that copyright belongs to so and so, so that you put it on the face and they get irritated by saying that who's the owner. I mean, in a very in a pleasant way, in an aesthetically pleasant way.
Great tips. Thank you so much. And I guess the very last question that I want to ask is this concept of royalties. And this came up a lot in our RSVP forum. And I think some people have also asked it in the Zoom and YouTube chats as well. So how can artists create royalties? Because they're often getting commissioned for these works and everything like that. So the concept of royalties, how can they get royalties for their creative works?
That's purely on agreement, right? So if you outrightly sell a property, you don't have. So I keep going back to the corporeal example, right? So you buy a townhouse, you either live in it or you lock it up and don't let others live in it. But if you let it out on lease, then you get a royalty. Similarly, you have a work of art or creative work. You can keep it in your pocket. Don't display it to anyone. If you want to put it up on YouTube, YouTube might, if you go beyond 100,000 views, they might start giving you money. That's also royalty. Or you can outrightly, give it off and say for 10 years, you go monetize it and give me 1 cent for every dollar you make. That's also royalty. But boils down to what you want to agree with the person who you give a, permission to use it for.
Awesome. With that, thank you to Bharat and Leah for educating us on so many different facets of IP protection today. And I'm going to hand it over to our CareSpaces core team member, Guhan, to sort of do a quick takeaway on everything that we've learned, and make sure that you're following along on your handout to sort of fill in any areas that you may have missed during the course of the session. So Guhan, go for it.
Thanks, Kritika. And thank you to both of our panelists. Very informative session. So in session 1, we went over sort of the 10,000 foot view about what this series, I'm a Professional 2, is going to be about. We established the basic vocabulary with which we were going to discuss the topics that we were going to talk about. And we also introduced the idea of formal and informal spaces. We recognized that there's nuance in all of these things, and that the conduct within these spaces perhaps would be greater or of more importance than the space definitions themselves. We also introduced a minimal yet comprehensive set of stakeholders who comprise the Indian art spaces. And in this session, what we did was we went over several scenarios or case studies which we felt are illustrative of issues that are surrounding creative IP in the arts. So in general, it's best to think about the long view of any artistic work. So where do you see it being performed, by whom, and for whom? And it's not an expressed form until it's reported to an agency, for example. And this notion that ideas are protected is false. Ideas are not protected. And you'd want to copyright things you have ownership for so that you want to prevent the copying of it. There's also a distinction, we went over this, between a creator and an owner. And there are cases in which you can be both, but there are often distinctions, and it's best to be mindful of those distinctions. It is also increasingly murky when you go into the environment where you have collaborative or commissioned work, which in the Indian arts is the majority of cases, actually. So it's always best to have a written agreement, which limits the work in time or territory or medium. So who owns it, for what, what is it, and who owns it for how long. And obviously there's nuance and subjectivity in each one of these cases. We went over the J. Devi case where the Madras High Court decided that the rights to the dance drama produced by Sri Lalgudi Jayaraman belonged to the creator because there was no explicit agreement establishing that Lalgudi was not the owner of the work, despite there being a payment for the production of the drama. So this actually establishes an important precedent where in the absence of an agreement, the creators hold the rights. So sort of a sweat of the brow argument where whoever put in the work will have that right. So I'll be going away also the takeaways from each perspective from each stakeholder that we introduced in session 1. So from the angle of a performing artist, to protect your own work, having some sort of written description of your own art and filing could always help clear things up. And this notion of innocent copying or not having a mens rea or intent is no defense for doing the copying itself. So be mindful of that. And there's obviously subjectivity here, but inspiration versus copying versus incorporation or integration of somebody's work into your own, it's probably best to speak to someone who knows the law beforehand, especially if you're doing it for a non-fair use and putting it out for your own viewership or whatever it might be, kind of consumption. We also, ask permission rather than to beg forgiveness is the kind of motto there. Now for performance or tour organizers or other people that are in supporting roles, such as makeup artists who are responsible for how you look on stage, photographers or videographers who are responsible for putting what your product is out in the digital format, and audio lighting people, volunteers, whatever they might be, agreements are definitely the best way to go. You can establish producers, you can establish commissions, you can establish owners and creators. All these things become explicitly clear when you have an agreement beforehand. And finally, we talked about royalties, which, as Bharat was mentioning, there's a lot of nuance and a lot of different ways you can split up the pie. you definitely want to defend yourself and defend whatever goes to whoever person in whatever written agreement that you want to do. But it's important to have that agreement somewhere in writing so that no disputes will be had. Finally, we talked about this increasingly digital age, especially during the pandemic and online connoisseurship. Regardless of whether or not you're consuming something digitally, you might encounter plagiarized work or may be tempted to plagiarize something yourself. So basically the consent will come from the owners first. And once that's done, then you can appropriately credit them and then you're in the clear. There's also the Digital Millennial Copyright Act, or the DMCA, which is meant to protect intellectual property of owners online. In order to report the content, though, you have to be the owner of it. There are also some cases, and I know Ravi touched on this with his question, where this is not necessarily applied correctly. And you might run into an issue where there's something that's in the public domain where you're applying, where somebody has applied some sort of unique creative license to it and copyrighted it, but you attempt to perform that same public domain piece with your own interpretation of it, and something gets flagged by YouTube or wherever it might be. So you can fight those cases. You can make sure that if you feel that you have distinct ownership of it and the creative intellect is involved, then you don't need to worry about it as much, but always be mindful of the fact that this is there. With that, I believe that wraps up this session.
Awesome. Thank you so much, Guhan. A special thank you to our speakers today, Bharat and Leah. We appreciate you adding value to the space and adding value to this topic that is so close to our hearts. And thank you to our workshop participants and everybody who joined on YouTube. This certainly conversationalized the topic for us to give us context. Stay tuned to our Instagram and Facebook accounts for more information on I'm a Professional 2 events coming up. You don't want to miss them, trust us. And thank you to my co-moderator, Kritika, as well, for handling such a beautiful session.
Thank you, Ratipriya. And I want to put a quick thank you to SNS Arts Development Consultancy and specifically Shreya Nagarajan Singh for collaborating with us on this whole series. We couldn't have done it without them and their unwavering support. So thank you, and thank you to all the back-end help that they've been providing for this session. I also wanted to put in a quick word that many people were DMing us, asking us whether this was going to be available later. So look out for session summaries and a filled out version of the handout that we gave you all. And we're going to find a way to sort of get the slides and make sure that this session is available for public viewing a little bit later. And in terms of legal resources, please follow CareSpaces. I can share the Instagram handle in the Zoom link, and maybe we can post it in the YouTube chat as well. We have a lot of cool resources coming up, and we just recently launched our peer support program for stakeholders in the Indian art space. So please check out the link in our bio for more information on that. And we're going to have some really cool legal resources coming up for all of you at the end of our I'm a Professional 2 series. So make sure you attend all the sessions to get a clue into what we might be providing for you later on in June and beyond. So thank you all again. Thank you to our panelists, and I hope you have a great week and a great rest of the weekend. Thank you.